What do you do for work?
I own this business, and then I also do some real estate as well.
What do you do? You got your real estate license?
I do not. No, we manage. My dad has commercial properties, so I help him with management of that.
Okay.
I dabble in a lot of things. This is probably my primary income as far as that goes.
Numeric.
It's a PIN.
What's the PIN number for it?
Am I required to give that to you?
You're not.
Okay. I'd rather not.
Okay.
Yeah.
I'll
Hey everyone, it's Katie from Without a Crystal Ball. Welcome back to my channel. I hope you're having a wonderful day. It is Tuesday, May 24th, and we finally have some answers about the case related to Josh Duggar. If you missed my interview with Caleb Williams, I just uploaded the 52-minute episode where I talked with him in detail about his situation with the Duggars, and now we're going to talk about what happened in court this morning because the judge has finally made a decision about Josh's case, and that is not good news for Josh, but I guess very good news for those of you that are hoping for justice. So after months of waiting for a ruling by the judge, Judge Brooks published a 29-page brief this morning with a memorandum about his motions to dismiss or for an acquittal. And he actually denied the motions. So he said this: Mr. Duggar brings a post-trial motion for judgment of acquittal under Rule 29. He argues that there is no evidence which the jury could base the guilty verdict on as to each count. He also requested a new trial under Rule 33A as an alternative, due to the government's alleged failure to timely disclose certain evidence and the court's ruling on witness testimony. The government filed a response in opposition to the motion, and Mr. Duggar filed a reply. For the following reasons, the motion is denied. So in the overall brief, we're not going to go through everything. Basically, he explains that there was way more than enough for anyone to actually make a decision on his guilt or innocence, and that there was more than enough evidence from that standpoint. He actually expressed that it's very difficult for a verdict to be overturned at this point in the case because district courts just do not set aside verdicts unless it's a massive miscarriage of justice. He said there's a quote from a case which says the district court will only set aside the verdict if evidence weighs heavily enough against the verdict that a miscarriage of justice may have occurred. And that was from a 2004 case. So Josh Duggar's case, his arguments for a new trial and for acquittal were based on the fact that he believed that there wasn't sufficient evidence to prove that he actually viewed anything that was on his computer. And he says that he claims proof of viewing is necessary to establish the needed mea rea needed to support convictions for receipt and possession. To be clear, he agrees the images presented at trial meet the definition of this. His argument is that no reasonable jury could have found he knowingly received and possessed this because they didn't have sufficient evidence that he or anyone else for that matter actually viewed the images. So in that respect, he said that his arguments lacked merit because there was ample evidence that he viewed the images and that they had been downloaded to his business computer. He brought up the testimony of Amber Calmer, the detective in the case who established a connection to Josh's computer on the peer-to-peer network, and they explained what Amber Calmer was able to actually extract from his computer, which we will not go into detail. And then he explained about the forensics of the actual HP computer Linux partition, and that pesky, it was done by a remote user. The part about how he created a Linux partition, he said the government James Fertel testified in detail about the analysis of an exact copy he made of the computer's hard drive. He observed that the computer user had partitioned the hard drive into 2 sections. On one side of the hard drive was the business side. On the other side of the computer, this side booted up the Windows 10 operating system and contained business records and applications needed to operate wholesale motor cars. The Windows side also had an application installed called Covenant Eyes, which monitored the user's internet searches for content, and then he would get reports sent to an accountability partner. And he said that on the other side of the drive was where he viewed and downloaded all the other stuff, and that was on the Linux operating system. And so one of the big things at trial was that his defense was trying to say that the Linux could have been booted or installed by someone offsite. That Mr. Fertel testified that the Linux operating system did not come pre-installed, and the user purposely installed it on the partition of the computer's hard drive. Mr. Fertel also explained to the jury that it would be impossible for the user to boot up both operating systems at once. The default operating system was Windows, which was used to run the business. If the user wanted to boot up the Linux operating system, he would have to bring up the boot menu and press a function key. In other words, the user needed to be physically present at the computer to boot up and access the Linux side of the hard drive. After sort of explaining how the operating system was set up and how Josh had to be there, and there was some discussion about what was actually found on the computer by the James Fertel and all the different images that found, the videos that were found in the unallocated space, and everything that had been recovered that had been deleted. He explained through the testimony of James Fertel how they could prove that the images were actually viewed and videos were actually watched through specific thumbnails that were left on his computer in a unallocated cache drive or some sort of cache drive. And after he explains that you had to be there to download the Linux partition, you're the one that had the reason to have the Linux partition because of this program you're trying to get around that's on your computer, the Linux, the Covenant Eyes. There was more than enough evidence for them to actually render a guilty verdict, and there was more than enough proof that you watched this content. But we don't even have to prove that you watched the content because it's irrelevant to your arguments. So he denied the motion to reverse the guilty verdict and to acquit him. So the next aspect that they talk about is this Brady violation, where he asks for a retrial, and he claims that this is because of some communications that they had with Caleb Williams, and that the government delayed in getting the information to them at trial. So in the alleged Brady violations aspect of it, he says, Mr. Duggar's first argument in favor of a new trial is that he was material prejudiced by the government's delay in disclosing certain pretrial communications with a possible defense witness named Caleb Williams. Mr. Williams was one of several individuals Mr. Duggar's attorney identified by name during opening statement as having had the motive and opportunity to commit these crimes. In fact, defense counsel told the jury the case was a classic old-fashioned whodunit and suggested they would investigate this case together because law enforcement failed to do so. They emphasized that the agents buried their heads in the sand for a 30-month investigation, failing to investigate anybody else than Josh. And in the end, the defense's promise of an alternative person came to nothing, as the evidence at trial showed that Mr. Duggar and only Mr. Duggar was physically present at the car lot when things were being downloaded. So that's sort of the information, is that, they talked ad nauseum about how, there was going to be all these different people that they blamed, but they never brought those people to the witness stand because they couldn't prove it, because all the evidence that was presented by the government proved that Josh was the only person there. They bring up the fact that Caleb sent emails on the 24th and then on the 30th. And they also bring up the fact that the emails were unsolicited and they were sent to the government's counsel. And they also said that they received that they didn't disclose them until December 5th, which was towards the end of the case in chief. So he explains that about the emails, he said the evidence presented at trial showed that that this stuff was downloaded on the desktop computer during a 3-day period in May of 2019, the 14th, 15th, and 16th. The court agrees with Mr. Duggar that Mr. Williams' pretrial physical presence at the car lot several days before the downloads was relevant to the defense. The government acted appropriately in disclosing that to his defense. He does not explain or quantify the nature of any prejudice associated with 5 or 6 day delay in the government's disclosure of this email on November 30th. And the November 24th email states that he was possibly present at Wholesale's car lot from May 8th to the 11th, several days before anything happened. Mr. Duggar expressly identifies Mr. Williams as a potential alternative perp, but the government had failed to thoroughly investigate him. Mr. Duggar states his knowledge that Caleb Williams regularly used the desktop in the months and weeks leading up to May 2019. He has sold a car on behalf of Wholesale Motor Cars on March 27th and used the HP desktop computer to print printing labels. For the reasons the government disclosure of this email before the trial may not have bolstered what Duggar already knew, but the delay in disclosing it did not prejudice the defense in any way. So because he identified Caleb as a witness and not the government, like it wasn't their responsibility to know this. And Josh knew all of this ahead of time. So he knew when Caleb was there. He knew that there was stuff printed out. He knew the timeline of all of it. So they're saying there was nothing in these emails that was new to you. And there was another email that he sent on the 30th about emails and such, giving more details about whether or not he was there. He says, Mr. Duggar argues that if counsel had only known about the November 30th email on the first day of trial, he might have been able to impeach the case with evidence that yet another person had access to passwords. Mr. Duggar maintains that he would have pointed out to the jury if he had the email in hand that the case agent failed to investigate all leads and seriously consider evidence of an alternative person. It says, contrary to Mr. Duggar's assertion, defense counsel did in fact cross-examine in the case agents and attempt to impeach them regarding the thoroughness of their investigations and their search for alternative people. And during this, Agent Faulkner testified that there was no one that followed up with Mr. Williams to ask him about passwords because Mr. Williams was in the state of Illinois when things happened. He concludes based on that the November 30th email does not impeach any evidence with respect to the case agents, and their credibility could not have been impeached for failing to ask Mr. Williams to list all of Duggar's family passwords he knew, because the evidence was clear that Mr. Williams could not have done what he did. So basically the fact that he had passwords wasn't evidence that he'd done anything, because they already proved that Caleb would have had to physically be there to do this, and he wasn't physically there. He was in Illinois. So having passwords was irrelevant and kind of in a way a red herring. He says, for whether this email could have been used to impeach Mr. Williams, there is no dispute that the defense was in possession of the email 2 days before the planned call to call Mr. Williams to stand. In addition, as will be explained in further detail below, Mr. Duggar's counsel made the strategic decision to not call Mr. Williams to the stand, though he could have done so, according to delayed disclosure of the November 30th email, did not violate Brady. So they go into detail then about the several different meetings that they have in chambers with Josh's defense counsel about Caleb Williams. And he brings up a specific conversation they have in chambers where he explains to them that in order for Josh to point the finger at someone, he actually had to have proof more than just like speculation, and that they had not established a nexus that actually was a straight line of Caleb did this. So because there was no straight line that Caleb did this, it would only be speculation, and there was no foundation of him being guilty in this case, so they wouldn't be able to ask him specific questions. Then he goes into the fact that during one of their chamber meetings, he finds out from the government that the reason why they were going to call Caleb was because he was on the SO registry. And they said that the defense team possessed no non-speculative evidence that he was in Arkansas on the dates in question. And they argued the only reason that he wanted to call him was that because of his recent SO stuff. And so they go again into a conversation that happened between him and a counsel, and the fact that Caleb was there to watch the lot, the court told him that wasn't good enough to place him there. And after some back and forth, they request another sidebar after he tells them, you can't bring him up here. You can't talk about this. He wasn't there on the days in question. They go again into the back room to talk about it. And again, they find out that they don't have any proof. Watching the lot, eBay sales, emails for shipping labels, none of that placed him at the lot on the days in question. And there was ample proof that he wasn't there. And so they couldn't use him or introduce him as an actual third party for this. And in regards to Josh actually being prevented from calling Caleb, they said this: the court then expressly permitted Mr. Duggar's counsel to call Mr. Williams to the stand, and the court suggested asking him preliminary questions to establish a background of who he is and what his connection is to Mr. Duggar's case, as well as the dates of his employment. The court reserved ruling on whether defense counsel would be permitted to take his questions a step further and suggest that Mr. Williams may have committed the acts. Before counsel could do this, the court required that he lay a proper foundation, which said, you must ask Mr. Williams whether or not he has knowledge of or recollection of being present on the car lot on May 13th through the 16th. Defense conduct is 14 through 16. But there's evidence that the Linux partition was installed on the 13th, and you may inquire if he ever remoted into the office machine, and if so, the time periods in which he would have remoted in. So they would have been able to ask him questions, but they would not have been able to go further if he would have said no to any of that. So after going back and forth for multiple days about the same issue related to Caleb Williams, they said, without proof of a non-speculative nexus between Mr. Williams and the offense conduct in this case, the jury's knowledge of his SO conviction was of little probative value and would have misled the jury and created the danger of an unfair prejudice, all of which are legitimate grounds to exclude this evidence under Rule 403. Mr. Duggar is not entitled to a new trial on the basis of this argument. So they didn't have anything more than speculation. They couldn't prove he was there. They couldn't prove that he remoted in. They proved that the remote access wasn't available. They couldn't do this through the remote access. So therefore, just because they didn't get what they wanted with calling Caleb, that didn't ruin Josh's case. So he doesn't get a new trial for that. He says, Duggar's next argument is that a new trial is warranted due to the government's failure to disclose certain exhibits Mr. Futrell used during his rebuttal testimony. The exhibits were screenshots he had printed while working with Oracle VirtualBox, and which was described as a very popular piece of visualization software. As he explained during the government's case in chief, Mr. Futrell converted forensic images into a format on Oracle VirtualBox. Then he configured a virtual machine to match the configuration. It's just a method to visualize the computer. It's basically like an exact copy of what he was doing, so he doesn't actually hurt the evidence. And he said, Futrell explained that he saved numerous print screens as he was navigating around the computer, looking at different things. He went through the process multiple times. I would go back periodically to create additional print screens for things I forgot to do the first time around. I rebooted the virtual machine multiple times to get the point to illustrate the things that I thought were effective to illustrate. So he sums it up in this way. If the government's disclosure of the screenshots violated the Jenks Act, a new trial would only be justified if the screenshots were withheld by the government in bad faith and resulted in prejudice to Mr. Duggar. It is clear that Mr. Duggar failed to establish the screenshots were withheld in bad faith. He concedes in his brief that the government was unaware that the screenshots occurred prior to his testimony the previous week. He also failed to prove that he was prejudiced. As previously explained, Mr. Futrell orally testified about the creation of the Dell One username on direct, and similarly on rebuttal. He used the screenshots in rebuttal to aid the jury's understanding of his testimony. The substance of his rebuttal testimony had already been disclosed to the jury during the government's case. It follows that Mr. Futrell uses the screenshot as a demonstrative rebuttal exhibit did not result in the kind of prejudice that would warrant a new trial. Basically, that screenshot proved that Josh would not need he would not need to do like installation of things with a code, and he could create his own username. They were trying to argue all these different things, like it couldn't have been downloaded from the store, and it couldn't be done this. And so he made a screenshot which showed that you could do these things. And Josh said that that wasn't fair. And then finally, they say that James Futrell wasn't qualified to talk about geolocation, and he said that that's not true. He said that obviously the technology at issue if Crawford is dissimilar to low-tech geolocation testimony Mr. Futrell offered at Mr. Duggar's trial, which is considered of plugging coordinates into Google Maps. So Mr. Duggar made no such he said that Mr. Duggar made no objection at trial to these geolocation tabs and Futrell talking about it. And so the court finds no merit for his request for a new trial based on his testimony on geolocations. So he didn't want the testimony that placed him at the trial, and so that Futrell was not qualified to speak to geolocations, which ultimately Josh's case is not going to go to a new trial. He's not going to get acquittal. And he did not rule about a dismissal of one of those charges yet. So there's one thing that was on the table, but he denied the motions for a new trial and for an acquittal, which means tomorrow we go to sentencing. Josh is going to go to prison, no new trial, no acquittal. The only way he's going to get any of that now is if he gets a successful appeal, which is going to be very unlikely. So with all that said and done, the judge clears Caleb Williams. He says, Josh, you didn't have enough evidence to prove that he was there. No one was prejudiced by this screenshot. There was no, Futrell had more than enough reason to be able to, more than enough expertise to speak to geolocations. And there was more than enough evidence for a jury to come to the conclusion that you did this. So Josh's arguments are getting squashed in every single direction, and he's going to go to prison tomorrow, you guys. So are you glad to hear that the judge has ruled? What are your thoughts? Tell me in the comments below. Bye, guys.